Hi, I'm Nadine. Welcome to the Don't Get Bitter, Get Better series. I created this series because grief will take enough from you, and I refuse to let confusion and being unprepared take anything more. This episode is called The Legal Business of Being Widowed, Part 1. And before you click away thinking this doesn't apply to you, stay with me, because whether you are widowed, whether you are a caregiver, whether you are perfectly healthy or you are someone who simply likes to be prepared, this episode is for you. When I lost Greg, I was suddenly standing in the middle of an ocean of legal, financial, and emotional decisions, most of which I never imagined having to make alone. Some of them I was prepared for, and some of them I wasn't. And the ones I wasn't prepared for, those cost time, energy, and peace of mind that I could not afford to spend. Today, I'm sharing the essential legal documents that helped me find some clarity and some control during one of the hardest seasons of my life. But before we go any further, remember my legal disclaimer from episode number 1? I am a lawyer. I'm just not your lawyer. And nothing in these episodes is legal or financial advice. Okay, let's get into it. These are the 4 main legal documents I currently have in place. First one, healthcare power of attorney. Second one, general power of attorney. Third, living will. And fourth, last will and testament. Okay, I'm gonna walk you through all 4 of these documents. I think these are documents every person watching needs to understand right now, not later. Okay, let's take them one at a time. First one, healthcare power of attorney. This is sometimes called an advance directive. And this allows you to designate a trusted person, your agent, to make medical and personal care decisions for you if you are ever unable to make them yourself. And I mean broad powers. We're talking about the ability to approve or withdraw medical treatments, to admit or discharge you from a hospital or facility, to access your medical records, and when the time comes, and I know this sounds morbid, to authorize an autopsy and direct the handling of your remains. But listen, what makes this document so essential is that it allows you to decide how far you want care to go. Do you want everything done to prolong your life? Do you want only comfort-focused care? Do you want something in between? You get to decide that now while you are clear-headed, while you are healthy, while you have the time to think through it. Because if you wait, someone else will decide for you. And that brings me to a case that I remember growing up, the Terry Schiavo case. Okay, some of you may or may not remember the Terry Schiavo case out of Florida. Terry unfortunately suffered a cardiac arrest in about 1990 and was left in a persistent vegetative state. Her husband wanted to remove life support. Her parents disagreed, and Terry had no written advance directive, no document that said what she wanted. What followed was years of painful public litigation, and in the end, the court sided with her husband. Life support was removed. The tragedy wasn't just the loss. The tragedy was that no one actually knew what Terry wanted, not with certainty, not on paper. And so the people who supposedly loved her the most ended up fighting each other in courtrooms for years over a question that she could have answered herself. And if I remember this correctly, her husband actually went on to marry the woman he had been with during those years after Terry was removed from life support. Don't let someone else decide your fate when you have the ability to decide it yourself right now. I've had a healthcare power of attorney since I graduated from law school. And every time my life has changed in a significant way, I have updated it. Pro tip, get your documents electronically whenever possible so that you can update them yourself as life evolves. Of course, for the simple changes that don't require legal direction. Life changes. Your documents should keep up with these changes. Okay, number 2, general power of attorney. A general power of attorney authorizes someone you trust to make financial and legal decisions on your behalf when you can't, or when you simply aren't available. I'm talking about banking and tax matters, real estate transactions, investment decisions, signing documents when you're traveling or unavailable. This is not a document you just hand out casually because it gives real authority to another person over your financial and legal life. So choose carefully and execute thoughtfully. So here's the thing I want you to hear about timing, and this matters more than people realize. Do this while you are physically and mentally able to give this authority. I cannot tell you how many times people try to get this document executed when their loved one is already sick, already in the hospital, already struggling. And depending on their mental and physical state, at that point, it may be too late. A person has to be of sound mind and body to grant this authority. Don't wait until you need it desperately. Do it now while it's a choice and not a crisis. Okay, third document, living will. Let me just point out, a living will is different from a healthcare power of attorney, and the difference matters. A living will is your written statement of your medical wishes. It is your voice on paper for the moments when you cannot speak for yourself. Mine states that if I'm ever in a persistent vegetative state with no reasonable chance of recovery, I do not want life-prolonging treatment. But, and this is important to me personally, I want you to hydrate and nourish me, because to me that is care, not prolonging death. So that's my version of human dignity for myself. Your living will reflects your values, not mine, not your family's, yours. And that's exactly the point. This document does something that I think is just as important as the legal function it serves. It lifts an unimaginable burden from the people who love you. It gives them peace. It gives them the ability to carry out your wishes instead of them simply guessing under the worst possible circumstances. That is a gift, a real one. A living will is a document. A power of attorney is a person. A power of attorney for healthcare is therefore different because it doesn't answer questions. It appoints a person, your agent, to answer questions that your living will could never anticipate. And here is the thing about medical crisis. They do not follow a script. The living will covers what you had planned for. The healthcare power of attorney covers everything else. Think about it this way. Your living will might say, if I'm in a vegetative state with no reasonable chance of recovery, I do not want life-prolonging treatment. That is clear, right? That is documented. That is your voice on paper. But what if the situation is more complicated than that? What if you are not in a persistent vegetative state, you are unconscious but not brain dead? What if the doctors are offering 3 different treatment options and none of them fit neatly into what your living will addressed? What if there is a decision that needs to be made right now in the next hour and your document simply does not cover it? That is where your healthcare agent comes in. Your agent, the person you named in your healthcare power of attorney, steps in and makes that call. Not based on what they want, but based on what they knew you would want. Based on the conversations you had with them. Based on the values you shared. Based on knowing you. That is why the conversation with your agent matters just as much as the document itself. The paper names them, but their relationship, the real, honest, hard conversation relationship, is what makes them effective. You need both, not one or the other, both. One more thing I want you to hear. Choose your healthcare agent carefully. Not the person who loves you the most, not the person who would be the most devastated to lose you, because that person may not be able to make the hard call when the call needs to be made. Choose the person who knows you, who has heard you talk about what matters to you, who can separate their own grief from your wishes, who will fight for what you actually want, even if it's hard, even if the rest of the family disagrees, even if it breaks their heart to do it. That is your person. And then tell them, have that conversation. Don't just hand them the document, hopefully they'll figure it out. Take a moment to sit down with them and tell them exactly what you want, what you're afraid of, what matters to you, what doesn't. Give them the gift of knowing before they ever need to use it. Okay, number 4, last will and testament. Your last will and testament is the cornerstone of your entire estate plan. It revokes any prior wills, names an executor, the person responsible for carrying out your wishes, and directs exactly how your property, your jewelry, your personal belongings, and your home are to be distributed when you are no longer here. The part I need you to really hear, your will does not control everything. Life insurance proceeds, bank accounts, retirement accounts, 401ks, IRAs, those do not pass through your will. They pass directly to whoever is listed as the named beneficiary on file with each financial institution. Let me say that again. It doesn't matter what your will says. If your beneficiary designations haven't been updated, the money goes to whoever's name is on that form. Courts will almost never override a named beneficiary. I have actually seen ex-spouses walk away with large life insurance checks, substantial checks, simply because the paperwork was never updated after a divorce. And the surviving spouse they were married to when they died, guess what they got? Zilch. Now that's crazy, but it is absolutely true, and it happens more than you know. Before Matt took his first international trip after we got married, we redid all of our estate documents, all of them. And yes, his ex-wife was still listed on all of them after several years of being divorced. And I want to be very clear. I have never heard of an ex-spouse that has just given life insurance money and other financial provisions back to a current spouse under any circumstances. So we made sure that the kids and I were legally and financially protected before he ever got on that plane. The point is this: you be in control of what you can actually control in your life. These documents are some of the most concrete, actionable steps you can take right now to protect yourself and the people you love. So do it. Don't wait for a reason. Don't wait for something to happen. Take care of you. Before I go, this is what I want you to walk away with today. These documents are not morbid. They're not about death. They're about love. They're about making sure that the people you leave behind, however many years from now, are not standing in an ocean of confusion. They're about giving the people who love you the gift of knowing. I'd love to hear from you in the comment section below. Is there someone in your life right now, a parent, a spouse, a sibling whose documents you have no idea about? And is today the day you finally have that conversation? If something happened to you tomorrow, does that person you trust the most actually have the legal authority to make decisions for you? Not just verbal wishes, but the actual paperwork. Who is your Terry Schiavo person? The one who would have to make the impossible call if you couldn't make it yourself. Have you ever actually told them what you want? Keep walking forward, and while you're walking, get your paperwork in order. I'll be here walking right with you. I'm Nadine, and this is Widowed Not Broken.